Hello, ladies and gentlemen. Welcome to Donna Just Being Real. My channel is all about dating, love, relationships, toxic relationship advice channel. If you need to reach out to me, look in the description. You will find my email address. And we can go from there. Need coaching and dating, love, relationships, and all that good stuff. Or you need to send something on the side. And okay. Sorry, echoing. All right, so we're gonna get into this. Now, this OnlyFans Courtney Clenney, I hope I'm saying it right, wants state's attorney to disqualified from stabbing case. All right, so this is a bit of an update. I've been covering this, and I don't know. This had happened like so many years ago. When are we ever gonna hit to the trial? When? But oh well, I'm following. I'll keep y'all updated. And when the trial does happen, I will definitely cover it if it's public. If it's private, can't do it. All right, ladies and gentlemen, let's get into this one. Make sure you hit the like, share me out, and all that good stuff. Now, the first thing I want to start off with is a clip. Now, we're going to show this clip from Law and Crime. Shout out to Law and Crime. We're going to watch this clip to get a little bit of idea of what this whole case is about, just in case if you're out the loop, because this happened a long time ago. And I know some people probably have forgotten about it. But, however, I didn't forget about it. I'm just waiting for the trial. All right. Look at her jumping on him. Okay, let's watch this clip and tell me what you think. And then also we're going to watch this clip to get an idea what it's about. Like I said, then also I'm going to show the main clip, the up-to-date of what happened in court. All right, so that'll be last. And I'll put in timestamps for people that's watching so you can navigate and get through get to the part that you want to watch. Try to make it a little easier. All right, ladies and gentlemen, let's get it. Hit the like. Date smart, not thirsty. And I think he was, you was dating thirsty. Yep. When you date thirsty, you will be a target of being used and abused. Resume. Let's get to it.
We've lost so much beyond just Toby. My aunt has never been the same.
Attorneys for the family of Christian Toby Abamseli, who was stabbed by his girlfriend, OnlyFans model Courtney Clenney, say they have new details about the response to their home by security that day. Thanks for joining us here on Law and Crime. I'm Anjanette Levy. Courtney Clenney remains in jail in Miami. She faces a second-degree murder charge in Abamseli's death in April of 2022. Abamseli's family is suing Clenney, the condo complex where they lived, and the company that provided security at the building for wrongful death. The attorneys representing Abamseli's family say they've discovered new information that employees for Allied Universal Security waited at the condo door as Abamseli and Clenney argued, and he died.
So on the actual date of this murder, the front desk at One Paradiso was notified that there was a dispute going on in Courtney's unit. At that point, they sent their security to the actual unit, and the security stood outside of that unit, despite hearing screaming, despite hearing this dispute going on, stood outside for 12 minutes while Courtney was able to get away with committing this heinous murder and did absolutely nothing until she opened up the door herself and was covered in blood. Her dogs were covered in blood. And by that point, Toby was already, unfortunately, passing away from her stabbing, from her murder.
From everything we understand, Courtney and Toby were known to have a volatile relationship, and the people at the apartment complex were aware of this and aware that there had been disputes. So they're members of security, not police. But what are you all contending they should have done? Because, security at an apartment complex can be much different from a sworn police officer.
I forgot to mention, and I see you, Melvia. Shout out to you, girl. I forgot to mention the speed is on 1.25. If it's too fast for you, you can always slow it down to your end. Hit the setting and adjust it to whatever's comfortable for you. All right, let's resume.
The defendants in the civil case, the security company, the management company, they knew this couple. They had been to this unit multiple times. In fact, in the very short 3 months that they lived here, there wasn't a week that went by that security wasn't called to the unit, that Miami-Dade police weren't called there. So they knew of this volatile relationship. They saw it firsthand. They saw the video in the elevator where Courtney is, hitting and being extremely aggressive, extremely volatile towards Toby. So they knew this history. Knowing this history, when they hear about another call, another fight to this unit where you hear screaming.
Melvia, I was looking at it a little bit earlier. I'm kind of watching with y'all. I just watched some of it. Yeah, I noticed that. She didn't see that in the mirror. Hmm. I think I'm feeling more of the her right, her left side. Yeah, it makes more of a brighter look. I don't know. Let's get back to. I'm not. I don't mean to pick on you, lady. I shouldn't be doing this, but we do notice. Resume.
and you hear all these things happening, at that point, security had to act. They had to do something to protect the other residents of that unit and to protect Toby from this woman.
I want you to get away from me! Get away from me! My bad. I said, hey, what's up? I'm going on a bike ride, and I forgot to tell you that I ran into somebody. Is that gonna make you act like this?
That's just one cell phone video that prosecutors have obtained of the couple fighting. They were also involved in an incident in Las Vegas in 2021. It's clear that the couple argued endlessly.
Decide whether or not you're done gaslighting me. Decide whether or not you're done gaslighting.
I am mad that you told me to come.
Decide right now.
Clemmey, that's a threat. I asked you so many times that I don't know, and I apologize.
Kim Wald, one of the attorneys representing Abamseli's family, said they also learned new information about Clenney's mental health.
So one of the other details that we have found out that is in the amended lawsuit is that just a few days before this murder, Courtney actually notified the management company and everyone else in the building that she had recently been diagnosed with a severe personality disorder that had not been treated medically yet. That in fact, that she was going to be put on medication to treat her for this illness. Now, after they received that notification, instead of continuing the eviction process, instead of continuing to remove this now known dangerous condition from their property, instead, the management company, the owner of the unit said, you know what? No problem. We're going to throw out the eviction notice. As long as you pay your rent, you can stay here, even though we know you're dangerous. And now we know why. It's because you have this condition, you have this disorder that is not treated medically. They allowed her to stay instead of removing her from the premises. And then we know a few days later, they received this call and again stood outside her door for 12 minutes instead of doing what they actually were required to. And that was to stop this dangerous condition, stop this murder from occurring.
What disorder is it?
It was a severe personality disorder. That was what was disclosed in her email to the management company.
The name of the personality disorder isn't clear. I spoke with Clenney's attorney about the civil suit back in May.
I can't speak to the other defendants in this case, the condo association, the security company, the landlords. But what I can tell you is this: that civil suit is seeking money. Okay, I truly believe the family is trying to make a money grab here, and it's the filing of this lawsuit was necessitated because of a change in law that was occurring. The family raced to the courthouse steps to file a lawsuit, probably prematurely.
Prosecutors and Abamseli's family have claimed that Clenney was the abuser in the relationship. Clenney's attorneys disagree.
And Jeanette, we've said from the beginning that this was a toxic relationship. There is no doubt that their relationship got physical on both sides. There was substance abuse involved on both sides. This is a self-defense case, and the facts that come out of trial.
I contacted representatives for the security company. At the time of this recording, they have not yet responded to my request for comment. Clenney's criminal trial may not start until next year. For Law and Crime, I'm Anjanette Levy.
I know what justice is.
Okay, ladies and gentlemen, just give me a second here while I get into the main video. Let's get to that one. Okay, ladies and gentlemen, now we're going to get into the main thing, the update of what's going on with this whole trial on Law and Crime. OnlyFans model wants state attorney to disqualify from stabbing case. Yeah. Okay, let's see what happens. I really want to know what's going on with this personality disorder. I think I kind of know what it is, but we have to find out. I think borderline personality disorder is one of them. Trying to figure out whatever the rest is. Probably histrionic and borderline. Yep, she seems more like that. All right, let's get into this, ladies and gentlemen. If you didn't hit the like, hit it now. Let's resume.
So are we ready to go? We have defense counsel here, state here, defendant is present. You guys ready to go?
Yes, Judge. Sean Abuhoff on behalf of the state, along with Kathleen Hope.
And Frank Vieth on behalf of Ms. Clenney. She's present before the court, and also co-counsel Ms. Pugliese.
So we are here for defendant's motion to, or amended motion to disqualify the state attorney's office. I was able to get through a lot of the binder. I've obviously looked through the motions, the response, and some of the case law, but we're ready to go. So defense.
Yes, Judge. You have the binder. I know you've read it. I
haven't read through all of it.
Okay.
That dropped off a day in advance, but I have to
Sure.
read through a lot of it.
Sure. And Judge, our written pleadings say a lot. And so I don't think this oral argument has to repeat everything that's already been delineated in our amended motion and especially in the reply. So I'm just going to highlight some things for you. So the standard is.
So for the standard and why you believe you met the standard and.
Yeah. So the standard to disqualify the state attorney's office is found in Downs versus Moore. And that is the defendant must show substantial misconduct or actual prejudice. And the case law that interprets what actual prejudice means is more than just an appearance of impropriety. But in the reply, well, in the state's response to our motion, they're highlighting most of the conduct that they've done after what I would refer to as the misconduct of ASA 20. The court is intimately familiar with those facts. You send the deposition, so I don't need to rehash the facts of that particular breach into the defense camp. What the state argues is that look at everything that we've done since. We've sealed the V case off. We've restricted access. I would just note that Mr. Quinn's still on the delivery list for pleadings, but we unclick him to kind of wall him off. But what I think is most important, Judge, is Mr. Abuhoff and Ms. Hogue. It's not what they did, Judge. It's what they didn't do. And what they didn't do, which is contained, I believe it's Exhibit A to our motion. Yes, it's Exhibit A. We have a letter. As soon as we realized upon the arrest of Courtney Clenney's parents and the allegations contained within the arrest warrant, it was clear that the state had obtained our work product or attorney-client privileged communications. As recommended by the Florida Bar, as soon as we realized that they were in possession of our confidential communications, we sent a letter addressed to Chief Assistant Kathleen Hogue, Sean Abuhoff, and Mr. Quinnen. That first letter was February 15th of 2023. The response to it was sent via email. The response we received from the state was complete silence. They didn't even acknowledge receiving this. Exhibit B.
Here's the 2-minute story of how I built a $10 million a year online business and how my mistakes and success.
Shortly thereafter, February 28th, 2024, same letter, second request. That was received, sent out via email, and the response to that request for having our confidential privileged documents back for communications was silence. Exhibit C. Third request, this one came February 10 of 2025. That was after the Chapter 119 revealed the email, the confidential privileged email. We sent the third request again. Ms. Hogue, Mr. Abuhoff, Mr. Quinnen. This third request for our work product and confidential communications again met with silence. So why is that important? The case law that we've talked about in the written submissions talks about substantial misconduct. And what does that mean? The case law doesn't say exactly what that means, but what the case law does say, every case needs to be looked at on a case-by-case basis. So we have to look at the facts of what has occurred in this litigation, and the appellate courts, again, would review that on a case-by-case basis, because every misconduct would, I think, be different. So what we have here is, again, the court's very aware of Mr. Quinnen's misconduct, but Mr. Abuhoff and Ms. Hogue, they had a responsibility. When they received these letters, they should have said, you know what, Frank, Sabrina, let's look into this. What exactly is it that you think that we have? They didn't do anything. So I believe their misconduct is by omission, which I think the court should consider in combination with the misconduct of ASA Quinnen in reviewing those materials, not disclosing that to the court, which is it's not a two-pronged analysis. It's substantial misconduct or it's not and. And what the state relies on is the actual prejudice. They're saying, hey, she hasn't been prejudiced. Nobody else has seen this stuff. But I think the analysis that we think is important for the court to consider is does the conduct of the state by acts or omissions rise to the level of substantial misconduct? And I think it has. They had an opportunity to do the right thing when they received our correspondence. Hey, let me investigate this. What are they talking about? Let's talk to Clinton and figure this out. Because if there was something done that was improper, they could have nipped it in the bud right there. And they did. So I think it's the combination again, the acts and then the omissions on the part of the state. And I think it rises to the level of substantial misconduct. The appellate court decisions, one that the state talks about is Nunez. We think this case is more similar to that of Martinez versus state, where ASA's heard jail calls between the attorney and the client. And in that case, in the Martinez case, the third district, I think it's the third district case. Fourth. In that particular case, that was affirmed on appeal. So it really is very unique circumstances that we're in. I haven't litigated a case of motion either on the side of the state or defense now 25 years. So it's an interesting topic. It's but I think that what occurred here, Judge, it's an abuse of discretion standard. I think there's substantial record evidence of what occurred and what should have occurred or didn't occur that would support, Your Honor, disqualifying the entire office. And that's what the defense is asking. The entire Miami-Dade State Attorney's Office should be disqualified.
Right, state.
Yes, Judge. So it's the state's position that the defense is misinterpreting the law on this issue. The defense wants to separate substantial misconduct or actual prejudice. But I think the case law is very clear, and there's a reason why quotations only appear around actual prejudice after the term substantial misconduct. And I think that's meant to define. There's a reason why in all of this, the case law on this issue, it only goes on to elaborate on this actual prejudice and what it is, and not just the mere appearance of impropriety. So that's the major part here. And if you look at all the cases that even the defense cites to, they all come about by some form of misconduct by the state. And the question just comes, does it rise to the level of substantial misconduct? And the analysis all comes down to, is there actual prejudice by the defendant at the time? And is there a fear of potential future risk of prejudice?
The website is called FastMoss. This is earning them thousands of dollars every single month. TikTok has 1 billion active.
And I think the defense, certainly wants to look at this individually and point to just substantial misconduct without a definition, whereas all the case law gives it to us. And when you look at those cases, there are plenty of them that are similar to this. You look at McWaters v. State, that the defense side of the Florida Supreme Court 2010. That's where the state actually even listened to jail calls between the attorneys and their client. So there's some form of misconduct that far exceeds what this can even be, but that's part of this analysis. And we have to look to and break down both who are the actors, and what is the prejudice that the defendant faces. And the question here is, does the defendant face prejudice right now in the position that she's in with Ms. Hogan and myself remaining on the case? And then if that is actually true, then the question would then move to the office as a whole. So I can take, and I would argue, Your Honor, that she does not face any prejudice, and we can break down the two breaches that Your Honor has found to be breaches. The first being the text communications. The defense points to these letters that they've sent to us, the February 15th and February 28th, 2023 letters that were received with silence. That's because after this all came about, we had all of this litigation on the issues of whether or not it was protected material on that computer case, that access case. Your Honor took control of those drives, and it's been in your possession ever since. So the idea of being able to turn back over these items, they were not in our possession. So I don't think we can be faulted for not responding to their letters. The content of those letters are important, though. And that's why McWaters becomes an important case, because in that case, in denying the motion for sanctions or disqualification, the court found that there's no evidence that the substance of these calls provided any benefit to the prosecution or were used in a way that detrimented the defendant. So McWaters goes on to explain that when you look at the context of those communications, there was no detriment to the defendant at that time or any future risk because the calls were what they were. These communications, the only person who reviewed them was Mr. Quinn in the original format. The world has had an opportunity to review them in the arrest warrants and in the search warrants. And what is clear is that those are just discussing the access of the computers. So there's no prejudicial information within those text messages that either myself or Ms. Hogue have seen, or really anybody in the world has seen. And through Mr. Quinnan's deposition, he did not even see. It was limited to just that. So from the context of just the communications of those text messages, there's no work product, or I should say no defense theory of the case. There's no strategy concerning the homicide prosecution itself. It merely is the access of this computer. That being said, again, myself and Ms. Hogue did not access this. So as we sit here today, there is no actual prejudice that the defendant faces. It cannot, I don't even believe it rises to the level of an appearance of impropriety, but that, even if it did, that is not enough. But I think the analysis really, and the harder question here is now moving to that, and I termed it in my motion, the Puglisi email. What's clear is that no one that is currently on the state's prosecution team had an opportunity to review this. Mr. Quinnen himself did not remember this item because when Your Honor ordered every part of the communications turned over to you, this would have been included. This is part of that. This doesn't come about until there is a public record request. And that is when the defense sends us, once they're made aware of it, they send us a letter to have us turn it over. Again, it's met with silence because we don't need to respond to it, but we do take action in it. And that's the importance. Myself, Ms. Hogue has come before this court and stated that we have not viewed it and we don't plan to view it. And I don't believe anybody in our office could ever view it because I've been able to verify it has been deleted from our servers. So the only person who accessed this is Mr. Quinnen. And in his deposition, what was clear from that was the only thing that he remembered from it was the name Mr. Haas, which was their computer expert. And again, going towards that investigation, that separate matter. So when you look at that, that is the Nunez case very specifically. It is a person who accessed, an individual who accessed attorney-client information and the contents, and we have no problem with stipulating that the contents would be prejudicial if the state reviewed it. Mr. Quinnen does not remember the contents of it. His only knowledge based on the deposition is the Mr. Haas aspect of it. And so he's also stated in that deposition, we've affirmed he has not discussed with anybody in the state attorney's office the contents of that document. So that goes to the Nunez case, which in that case they found, based on what the court deemed as misconduct, did not rise to the level of substantial misconduct for the office. It did for that prosecutor. They removed that prosecutor, but not the office. So that's why this is not State v. Martinez. In that instance, that prosecutor, not only that prosecutor, other prosecutors heard the calls and were discussing throughout the office. The state has done its proactive work to ensure that the rights of the defendant aren't violated, that the defense team's communications aren't overheard, and we have a filter protocol in place for all of this. Your Honor has been made aware that once, and if Your Honor rules to not disqualify us, we have someone coming to receive these drives to ensure that that is all filtered out. We have no issue with allowing the defense to review those drives prior to any of the prosecution team, or certainly the court, if Your Honor wants to review them. We have no issue with doing that, and I think that's the appropriate thing now that we're here where we are. So we can ensure that there's no more of those text communications that can be reviewed. Concerning this document itself, again, it's been wiped from our servers. No one can access it, and I've been able to verify that. So that's why this does not go to the State v. Martinez case, and this is the Nunez case. Bless you. The other part is that Mr. Quinnen has been screened off the case, and that's why I created the analogy of this is different from the Popjoy case, which is a third DCA case from 1992. That case, the office that was taken off of the case, too small to be able to handle that situation. And so the dissemination of information was inevitable. That's not what this is. The Miami-Dade State Attorney's Office is one of the largest in the country, one of the largest in the state of Florida, possibly the largest in the state of Florida. We were able to screen Mr. Quinnen to where he doesn't have access to the electronic file. He doesn't have access to the hard file. He doesn't have access to myself or Ms. Hogue. And actually his office is on the far reaches of the state attorney's office where we don't have to interact with him. So we're able to ensure that.
What if your website's success was only limited?
He has seen, which the deposition shows that there really isn't any prejudicial information, would not come about or would be discussed with the current prosecution team. So that screening process is an important part and why there is no risk of future prejudice that the defendant might face. So, Your Honor, based on the arguments that I'm making, as the defendant sits here now, based on what Your Honor has deemed breaches, two separate breaches, or one separate breach, but two separate items, there is no actual prejudice as she sits here now with the current prosecution team, let alone the office itself. And then the risk of any future potential breaches or prejudice, we believe that we've taken proactive measures to ensure that that will not be a concern for this court or the defense team.
Yes. Your Honor, it's, how can I put this? The credibility of the testimony by Mr. Quinnen that he just forgot, right? He forgot discovering the linchpin, the evidence that he needed to find the laptop, locate our expert. That is just, that Your Honor can evaluate the credibility of those statements. What the state is trying, and just let's talk more about what occurred. Mr. Quinnen disseminated that information to law enforcement. His testimony was he didn't disseminate it to anybody else in the office. We know that the copy of that email was on the servers, but I do believe, and I do not doubt Ms. Hogue and Mr. Abhoff's representations to the court that they did not view it. But going back, the state's arguing that it's substantial misconduct has to have actual prejudice, but it's an or. And the quotes, I would say, are because the Downs versus Moore doesn't say prejudice, it says actual prejudice. That's the distinction of the quotes. It's an or situation. So for that substantial misconduct, we have to look at what the conduct was of Mr. Quinnen, and then again, the omissions, I believe, on the part of the two prosecutors. In the case of Nespler, which I think the state and the defense have argued in our written pleadings, I guess that's the beauty of the law. We're almost citing the exact same cases, but interpreting them differently. And then Your Honor has to figure out that who's wrong and who's right in a somewhat of a gray area. But Nespler, that's spelled with a K-N-E-S-P-L-E-R versus State 314th Southern 3rd 287. That's a 3rd District case. And they cite to one of kind of the staple Supreme Court cases that addresses this issue, which is State versus Fitzpatrick 464 SO2D 1185, Florida 1985. So they talk about how the state is different than a law office. And they say there's a distinction between private law firms and government prosecutorial offices, and that's citing State versus Fitzpatrick. So as a result of that distinction, the Florida Supreme Court has recited that imputed disqualification of the entire attorney's office is unnecessary, meaning you can't do it or you shouldn't do it, when the record establishes that the disqualified attorney, who I would say here is Mr. Quinnen, right, has neither, one, provided prejudicial information relating to the pending criminal charge, which I think that's a tough sell, nor, meaning, and he also has not personally assisted in any capacity in the prosecution of the charge. Mr. Quinnen clearly, right, personally assisted in a whole bunch of capacities, right, in the prosecution of the charge. And again, that's, so why is disqualification of the entire office appropriate? Because he, Mr. Quinnen, personally assisted in any capacity in the prosecution of the charge. And that's at 1188 in the Fitzpatrick case. So, you know, we always, when I was in county court, and we were all, you know, in county court, the judges, when it's DUI Mondays, there's the state, oh, judge, this isn't my case. This is, I say, so where's he? He's in the hallway, right? Well, you are fungible. That's what we used to always get. Well, you're fungible. You can go ahead and try this case, Mr. Prieto. So it's that distinction. The state is kind of considered their one fungible body. And that's what Fitzpatrick talks about, is that if, I believe it stands for the proposition that if the attorney that was disqualified participated in the case, that's it. You can do it.
So why do I start things and never finish them?
So I think if you look at you know, the totality of the circumstances of the misconduct by act or omission, I think that your Honor would be on solid ground in the third if you disqualified the entire office.
Judge, if I could just clarification, no argument. For the disseminated to law enforcement, that Mr. Quinnen, that was only specifically those law enforcement officers were on the computer case, is my understanding. And if defense knows otherwise, I believe it's just the.
I believe that's correct. Yes.
Right. So that, and that's a different department than prosecuting the homicide. So I think that is also important to note, because that's also other screening that can take place, that there has not been discussions with those officers, as that case no longer exists. And the only other part would be that the Nespler case is a third DCA case that comes after the Nunez case, and Nespler does not discuss the Nunez case or call into question the Nunez ruling.
Judge, I do appreciate the state has tucked away Mr. Quinnen in the far reaches of the office. But you know,
He was stuck there before.
yeah, well, you know, we have to rely that he's not going to speak to anybody. And I think that that's the fear that the client had, and we have as a defense team, that there's nothing to stop the state from, well, we'll end it there, Judge. I appreciate the court's time and the hearing, and
Right.
appreciate the state's arguments.
That's for transfer below. I think I have to call the notes. Let me set up for my ruling. I want to go. It's going to take me a little while to go through everything to write it all out. So let's get 30 days. Then we'll decide. Okay.
Thank you, Judge.
Thank you, Judge.
Be like a status.
It's going to do 30 days to my ruling.
So would you like to do July 23rd? That'll be a Wednesday?
No, let's do June.
June. I'm sorry. June 20.
23rd might be on Monday too.
Yeah, it is.
Okay, let's do Wednesday. Sounds good.
Okay, ladies and gentlemen, I just wanted to do the update on this. Okay, so we see what's going to happen next. And like I said, I will keep y'all posted. And stay tuned for some more of Donna Just Being Real. And I'm getting ready to cover the next case. And we're going to get into this beautiful young lady. Her first date with this clown, this monster. And he dismembered her body. And her family has to look for all her body parts. And by the way, they didn't find all the body parts. So today was the opening statements. So I'll be focusing on that very soon this evening. If you can't come, hey, no problem. You can always watch the replay. That's what it's there for. All right, ladies and gentlemen. This woman is a piece of work. The day after she killed her boyfriend, what did she do? She was sitting in a hotel bar with her daddy having cocktails. Yeah, okay. All right, ladies and gentlemen, that's the end of it. Everybody had themselves a blessed one and a great one. And stay tuned for some more of Donna Just Being Real. If you need to reach out to me, look in the description. You will find my email address. We can go from there. Adios.